W1935 of 2016 matters on the roll for judgment.
As your ladyship, the appearances for Mr. FLG Medicine are the same as before, save that Mr. Morris is still today.
Please, the court, my lady, I appear on behalf of Iphc Modise.
Yes, thank you.
My learned leader is not available today.
Yes, I was told. Thank you.
Lady, the appearances for the 33rd respondent and first and second defendants in the action are the same.
Thank you. As with the previous judgment, I choose to read this one on the record because I have done so with the previous ones and for the benefit of the people who came here. If I'm not. You need to raise your voice, I can't hear you. Who can't hear me? Yara, I'll try. I see she's smiling, so it means she cannot hear me. I'll try. On 2 March 2023, Mr. Leonard Modise brought an application for my recusal following the court's order and judgment dismissing an application for leave to appeal brought on behalf of both Mr. Leonard Modise and Iphc Modise. Before dealing with the recusal application, I deem it necessary that one should have a background of facts in order to appreciate the circumstances which led to the court being required to consider recusing itself by Mr. Leonard Modise. It is not in dispute that the respondents approached the Deputy President of this division in a letter dated 18 March 2022, requesting him to allocate a case management charge for the consolidated matters under case numbers 11935 of 2016 and 14038 of 2019. In the beginning of May 2022, I was then appointed by the Deputy Judge President as the case manager and directed to deal with the matter, including intellectual applications that might ensue in the process. On 12 May 2022, my registrar wrote an email to all the parties informing them that I have been allocated the matter to case manage and to inquire if all the parties would be available to attend the case management meeting on 27 May 2022 at 10 in the morning. A case management meeting was then set up for 9 June 2022, and all the parties were present, and I gave the directions in respect of the days on which the parties were to make discoveries, request and serve further particulars, if any, in preparation for trial, as well as the proposed dates for the exchange of witness statements. I also indicated to the parties that not only was I allocated the matter to case manage, but I had also been directed to deal with the whole matter, including any intellectual applications that might ensue in the application in the process. The parties did not object thereto, and it was agreed that a further case management meeting would be held on the 14th of October 2022 at 9 a.m. and nothing relating to the merits of the case was canvassed or entertained during this meeting. Safe to say that Mr. Iphc Modise had not by this time filed his witness statement. The other parties had complied with the directive, and it was agreed that at this meeting that the matter was ripe for hearing, as it appears on the agenda for the day, where it is noted that parties are agreed that the matter is ready for trial. Further consideration related to the timeline for the preparation of the trial bundle and a trial date for 13 February 2023 was set and agreed to by all parties' consent. And as with the first meeting, I again indicated to the parties during this meeting that I would be sitting as the trial judge during the proceedings, and there was still no objection from any of the parties. On December 2, On 2 December 2022, the respondent sent correspondence to my office requesting to have an urgent case management meeting regarding issues which, in their opinion, are connected to this matter but are before other courts. This correspondence was not replied to, as I was of the view that it would not have been proper to entertain such issues which did not fall under the scope of the issues to be dealt with before me, and as agreed to by all the parties concerned. On the morning of 13th February 2023, when the matter was to proceed before trial, I was notified by Mr. Leonard Medice's counsel of the allegations of corruption against me that were making rounds on social media, apparently for quite some time. I was also warned of the presence of the media in the courtroom and that I should recuse myself if I do not want to be embarrassed before the cameras, and that an application in terms of Rule 37A would be made on behalf of both Mr. Leonard Modise and Mr. Tsepiso Modise. And it became apparent at that moment that the respondents were also not served with the intended application or informed of the intention to bring the application on the morning of the trial. When the matter was called in court, an application in terms of Rule 37A was made on behalf of the applicants, and this application was made from the bar without notice of motion and found in affidavit. The application was dismissed on the basis that there was an agreement and never an objection that I would be presiding over the matter, and further that there was no proper application before me. I then ruled that since this was an interlocutory application, the ruling is unappealable. I also informed the parties that the reasons for the order would be furnished later. The applicants requested the reasons which were not provided for at the time, and the next day they proceeded to make a formal application for leave to appeal the interlocutory order granted by this court. At the time when the application for leave to appeal was made, Mr. Leonard Modise had already filed and uploaded what is referred to as the conditional recusal application dependent on the outcome of the application for leave to appeal. The court was also informed by his counsel that a recusal application will be made later on behalf of Mr. Leonard Modise. I dismissed this application for leave to appeal and handed out a full judgment. An application seeking my recusal was thereafter brought, and I will now deal with the merits of that application. Mr. Leonard Modise is applying that I recuse myself and withdraw from presiding over the consolidated matters under case 14038 of 2019 and 11935 of 2016, as aforeshadowed by his counsel before the recusal application was lodged. The application is opposed by the respondents. The recusal application is premised on the belief of a reasonable apprehension of bias, which Mr. Leonard Modise alleged might result in him not getting a fair trial. The grounds for recusal in the entire application is based on the affidavit deposed to by a certain advocate Goodwill Babi Maluleke, herein referred to as Mr. Maluleke, which is attached to the founding papers and which seemingly have created all these rumors and the allegations which I referred to above. Mr. Leonard Modise acknowledged in this founding affidavit that the allegations are clearly hearsay in nature because he has no knowledge of the allegations as it was reported to him by Mr. Maluleke, that Mr. Twala, the respondent's attorney, had told him that he was informed by Mr. Sandlana, spokesperson, that I have been bribed by Mr. Sandlana to rule in his favor in the pending proceedings. He stated that because Mr. Maluleke has sworn to his version in an affidavit, he assumed that Mr. Maluleke, as an officer of the court, would not make false statements in an affidavit, and as such, he must accept that Mr. Twala must have told Mr. Maluleke that the judge had been bribed. He further stated that he apprehends, I'll repeat, he further stated that he apprehends that given the nature of the allegations, whether found to be true or not, I will not be able to exercise an open mind when dealing with the proceedings or presiding over the matter, and submitted that even if the allegations were not true, I should recuse myself. Mr. Leonard Modise further stated that the affidavit of Mr. Maluleke is said to have been delivered in the course of fraud proceedings pending against Mr. Sandlana. And in that affidavit, Mr. Maluleke relates how he was told by Mr. Sandlana's attorney that I had been tainted. Mr. Maluleke stated in his affidavit that he deems it appropriate to set out the, in inverted commas, relevant context which exposes paragraph 9 of the plea explanation given in a fraud matter brought against Mr. Sandlana, which he refers to as unmitigated attempt by Mr. Sandlana to impact his integrity and implicate him in a crime that he was not involved in. According to Mr. Maluleke, the relevant context relates to what he says is his in-depth knowledge of the truth relating to the claims of leadership of the church, having served as a member of the Council of Elders in the Iphc Jerusalem faction, being the highest decision-making body in the church and chaired by Mr. Sandlana. He states that he was a close confidant of Mr. Sandlana. It is clear from the reading of Mr. Maluleke's affidavit that there is a serious fallout in the relationship between the two, which is sparked not only by the fact that Mr. Maluleke had left the church, but by a series of events which, among others, involve a case being opened with the police. A lot of the issues have been raised in this affidavit, which I do not wish to address as they are irrelevant to the case before this court. Mr. Leonard Medise's contentions are based on paragraph 53 to 58 of Mr. Maluleke's affidavit. The nub of the paragraphs relates to a report made to Mr. Maluleke that I have been sanitized of us, but has been to the building in which his chambers are housed to brief other advocates. He avers that while Mr. Leonard Modise acknowledges the hearsay, what he fails to note is that much of what he alleges is what he refers to as a double hearsay of a kind that any other court would be loath to admit. If allegations made by Mr. Leonard Modise in his founding affidavit lacks the essential particulars and are solely wanting because the purported affidavit deposed to by Mr. Maluleke has not been confirmed, and neither is there an affidavit by any of the individuals whose names have been mentioned in his affidavit, whose input would be essential if serious weight were to be attached to these momentous allegations. Put differently, that it was not competent for Mr. Leonard Modise to attach the affidavit of Mr. Maluleke in the absence of a confirmatory affidavit by Mr. Maluleke. It was argued on behalf of Mr. Leonard Modise that having received the information about the allegations of corruption, Mr. Leonard Modise could not turn a blind eye to the information because it would not be fair for him as a litigant, hence he saw it necessary to bring an application circumstances. It was submitted that although it cannot be established whether the allegations are true or not, the fact that those allegations are made in an affidavit by an officer of the court, Mr. Maluleke would not have made false statements in an affidavit. Mr. Epstein argued for the respondent that the recusal application is a fabrication and was not brought bona fide. He further states that it was an absolute abuse of the court's process based on the following reasons. One, that Mr. Leonard Modise has stated in his affidavit that he is aware of the gravity of the application and that it was not brought frivolously, yet his entire application is based on what Mr. Maluleke has said in his affidavit, which is alleged to have been submitted in a case involving Mr. Sandlana. Number two, that it is not true that the said affidavit attached to Mr. Leonard Modise's application has been given to the police. that it is not true. I'm going to repeat that it is not true that the affidavit attached to Mr. given to the police, because this affidavit, Mr. Twala has not. Number 3 is that Mr. Maluleke has not confirmed that he is the deponent to the affidavit relied upon by Mr. Leonard Modise in his application, and thus making it hearsay. Number 4, that while Mr. Leonard Modise informs the court that Mr. Maluleke is the person known to him and does not know his whereabouts because he's hiding, the court is not informed of the steps taken to find Mr. Maluleke so that he can come and confirm his affidavit and be cross-examined on it. Number 5, that Mr. Leonard Maluleke, who has perjured himself, because it is inconceivable that in November 2021, when nobody knew that I would be sitting in this matter, and even before a letter was addressed to the DJP on the 18th of March 2022 to allocate a case management judge, that Mr. Twala would have met with Mr. Maluleke and told him that I had been sanitized. Relying on the case of State versus Zuma and another, which is referred to as the ruling and reasons for recusal, Mr. Epstein argued the proof bias or the apprehension of, and more particularly because the reports made appeared on the media. In emphasizing the importance of being properly informed as to the relevant facts when bringing an application for recusal, this court referred to the matter of South African Human Rights Commission on behalf of South African Jewish Board of Deputies versus Masuku and another, in which the Constitutional Court, in applying the test for recusal, stated the following, open quote, "The issue of recusal must be determined by taking stock of the objective facts, which can hardly be said to be found in the pages of the press. We have already determined and discussed the objective facts that are relevant to this recusal application, and are aware of no reason why anything in the media should have any bearing in this inquiry. We would easily find ourselves going down a treacherous rabbit's hole if the media were to guide our objective assessment of facts in cases that see. Considering the aforesaid, it is important to have regard to the timeline in respect of this matter. Although Mr. Maluleke deposed to his affidavit on the 23rd of August 2022, he makes it very clear that he was informed by Mr. Twala about the corruption allegations in November 2021. In this regard, Counsel on behalf of Mr. Leonard Modise stated the following when the importance of the timeline was raised in relation to the period made and the periods when Mr. Maluleke deposed to his affidavit. Open quote. Let's accept that there is something wrong with Mr. Maluleke's version. That is not the test. He may have gotten the dates wrong. Whether he lied or whether he was mistaken about the date, that cannot be objected. That Mr. Epstein has shown me